Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the Fourth Court of Appeals, District of Texas is now pursuant to law.
Good morning, everyone. Please be seated. The court will now call cause number 04-24-553 CV, the matter of Jonathan Paul Jones versus Raquel Hatch and James McCowan Jr. as the next friends of Taylor of McCowan. Announcements from appellant's counsel first.
And Your Honor, Melanie Fry and Brooke Boland for the appellant, Jonathan Paul Jones.
Good morning.
Mary Nicholson for the appellees, Taylor McCowan, the parents, Raquel Hatch and James McCowan Jr.
Good morning, team. Counsel surprised if your time, and when you're ready, you may approach.
May it please the court. Our Supreme Court tells us appellate courts have a duty to ensure that the damages awarded for non-economic injury are the result of rational effort, grounded in the evidence to compensate the plaintiff for the injury. Damages from mental anguish and loss of companionship are neither punitive nor exemplary. The facts of this case, Your Honors, are indisputably tragic, and nothing I say today is meant to diminish the suffering that we know these parents have endured due to the loss of a daughter. She was clearly a special person. The record makes clear that she enriched their lives. But the jury's verdict here was arbitrary, not grounded in the evidence, and meant to punish the defendant rather than compensate the plaintiffs. Apparent from the face of the verdict, the jury used numbers like Miss McGowan's age and the date of the accident with zeros appended behind those numerals to fill in the blanks. And the result was an astronomical award, over $81 million awarded, with interest comes to nearly $100 million. $44.6 million of that was awarded to the parents alone for the loss of an adult child with whom they did not live. Our system of justice and the holdings of the courts in our state demand correction of such an award, whether through remand or remittitor. And absent redirection from the court, I intend to address the damages in the following order. First, this excessive award of non-economic damages and the guidance we have from the recent Texas Supreme Court case in Gregory versus Chohan. Second, the pecuniary damages award without evidence that Ms. McCowan contributed financially to her parents with whom she no longer lived. Third, the $24 million awarded for conscious pain and suffering and survival damages. And then finally, the punitive damages award. Starting with the excessive non-economic damages award. This amount was $42 million for Ms. McGowan's parents. The court may be familiar with this recent case of Gregory versus Chohan. It has certainly captured the Texas bench and bar's attention when it came out in 2023. I think both for its holdings on non-economic damages and for the posture that the Supreme Court issued it in, where you had justices in a plurality, then part of it's a majority, and then two concurrences, but one reads more like a dissent. Very interesting to kind of dissect and see what are the holdings of Gregory. So we have just now Chief Justice Blacklock, who authors it, and we have Justice Hecht and Busby, who join him. Justice Bland is interesting because she concurs in the opinion, except for the two sections. So she says, I'm with it, except for these two, and then ultimately issues a separate concurrence when she says, look, I really want to leave a true discussion about applying this standard to another case where we don't have such flagrant closing argument error. Let's save it.
Which we don't have here, right?
Which we don't have here. We don't have the same kind of improper, talks of paintings and fighter jets. So what do we know from Gregory? We know many things. Here are the holdings. Not only must there be evidence of the existence of compensable mental anguish, there must also be some evidence to justify the amount. That's the majority in Gregory. That's citing and quoting the Signs versus Fidelity and Guarantee case, the Texas Supreme Court from 1996. We know that no matter the cause of action, the results of litigation should always be justifiable based on evidence and reason. Juries cannot simply pick a number and put it in the blank. You see that string side is long, right? Texas Supreme Court has long held that. Even non-economic damages are compensatory and not punitive. And then the Gregory plurality holding that is off-cited is this idea of the rational connection. We have to have some rational connection between the evidence and the amount awarded. So
Let's
what's
stop there. Of the citations the Supreme Court held and any cases that have been decided since,
Mhm.
which would you hang your hat on as being the closest in terms of factually, that's that's going to guide this court a little bit better about how much is too much,
Yep.
how much is not allowed, but more importantly, what kind of evidence should we be looking for to substantiate any award? And again, how much is too much? And is there any guidance from other cases before and after Gregory?
Yep.
And even within Gregory, what would you hang your hat on?
I am going to cite the court to a case post Gregory, and I promise I'm not going to cop out by talking so much about Gregory, but here's what we know about plurality opinions. A plurality opinion actually does control the result in identical cases. And in answer to your Honor's question, the facts of Gregory are nearly identical to here. And that's not just, oh, an injury occurred and they're evaluating non-economics. Traffic accident, vehicle accident, results in death, family members, 6 of them in Gregory, 2 of them were parents, right? Here we have the 2 parents. Similar evidence. So the wife testifies in Gregory and she says, of course, I was close to my husband. Heartbreaking testimony about how it affected the children to lose their father, both physically and mentally, about how their demeanors and personality changed. And then importantly in Gregory, testimony about how it affected the parents. So we're looking for similar facts, right? What will we hang our hat on? What we would tell the court, this is apples to apples. Here's what we apply. In Gregory, the testimony was the decedent was very close to his parents. Here's one difference. They lived with him. They lived together. They cooked together, gardened together. His mother cries several times a day. And the testimony was that the family's entire home life had changed for the worse. Of course, everyone was deeply saddened. Here's the other apples to apples. The dollar amounts were not the same. And yet in Gregory required reversal. In Gregory, the award to the parents was $160,000 for each of the categories. So we have past and future mental anguish and past and future loss of companionship. So those 4. So a total of $640,000. And they reverse. And they say the evidence doesn't get us there.
How old were those parents?
The decedent, I believe, was 50. I don't want to say it wrong. I believe he was in his 50s. And so the parents, I don't know that the opinion reveals their age. My best guess is going to be in their 70s, that they lived with both him and his wife and their 3 children.
Other than the testimony, other than the testimony of family members, were there other non-family or say expert witnesses who also supported or was offered or admitted into evidence in terms of, to support that verdict?
The burden fell on the wife. She got up there and testified both as to her own and to the children and the parents. The parents actually did not testify, if I recall correctly, in Gregory. She kind of bore the burden to lay this out. And it's interesting you ask about experts because then in the opinion, the court's saying, and Your Honor asked about this a moment ago, well, what would be some evidence to create a rational connection between the testimony she gave and the amount awarded? And of course, the Texas Supreme Court says, like, we're not gonna speculate and go into all the ways, but they do list some things throughout the opinion. And one of the things they list is expert testimony. They mention maybe the plaintiff could give some number, could offer some kind of amount. They talk about expert testimony. I promised the court that I would cite to you to kind of post Gregory opinions. And in some of those opinions, you have an expert taking the stand and saying, well, I'm going to tie it to the amount that they would have been able to earn in the National Guard and now they can no longer. And so we're going to use that as a multiplier.
That's a
Or
different line in the jury charge, right?
so the courts,
We're talking about the the mental anguish.
that's right. The court seems to be willing to use it for both, though, to say there's a pecuniary award for loss of wages, but then there's also some kind of rational connection that could be made to the value of something that's lost, and then a multiplier by the number of days that the person should have lived or the remaining days of their
Would
life.
it be, it would be a stretch to say that the Supreme Court would require expert testimony.
I agree. I think they're just offering samples. And I think the bar is continuing to ask them the like what
So
kind
this
of
is the thing
question.
on review, right? Because how much is, what's necessary? Is it the weight of the evidence? Is it the number of witnesses that testify? Is it the substance of the actual testimony? Or are they just, again, factual circumstances like you point out, living with, the connection? So in terms of like the standard that existed even with Gregory, it's the amount and the, what was the wording? So I don't know that there's any calculus about what we're looking for, but at least that there's there. And how much deference do we give to the fact finder, in this case, the jury, about what they would award for that loss? And that's where our job comes in and says, is that too much or too little? So again, what direction, based on what we find, has been, what the courts on review should be considering when, when reviewing these awards?
Your Honor is absolutely correct that there's not a calculus. What we do have is similar verdicts, case law examples. When we start with Gregory and we say 6 plaintiffs, 15 million, Supreme Court says no rational connection, too much. Parents, 640,000, too much. Then we have post-Gregory, Team Industrial Services versus Most. This is cited in both of the parties' brief. That was a 2024 case citing Gregory and reversing the mental anguish award. In that case, 165 million was the mental anguish, the non-economic damages award. And the court says too much. And so, I wish I could provide the court with a calculus and say, this is the formula. The Supreme Court refuses to do so, but looks at case law and says, in this circumstance, even death, even parents, even wife, that's too much. In this case, 42 million for parents of an adult child.
So the court in Gregory acknowledges that it's really difficult to determine non-economic damages with mathematical certainty.
Absolutely.
And I think you said earlier that you alluded to maybe expert evidence. I know that in Gregory, it was discussed that what counsel argued in closing argument. So but what about the jury itself, the fact finder using some kind of lodestar method? I mean, why should we discount that they did something like that in the jury room?
The issue of whether a lodestar is even appropriate, I think, has been called into question by, even 5 years ago, we would say, no, you can't do a multiplier. That's improper closing argument. Now we have the Supreme Court maybe suggesting that that's the way to do it. What I would say about the deference to the jury is that the discretion is not unlimited. Here we have an award where you have, 1, 5s, and 10s, right? With lots of zeros behind them, just these 1, 5s, and 10s. There was no evidence offered or attorney argument suggesting a lodestar or an amount or a multiplier. The only number we see thrown out by counsel in closing argument was $100 million, right? That was the number that was given. And then the jury awarded over 81 million comes in, and half of that to non-economic damages. The other telling thing as we're looking at what's enough to reverse, even in the appellee's brief, we see lots of references to, well, it was, a drunk driver who killed her. And this inflammatory language is used to justify a compensatory award. And so if the court looking at the record sees evidence of punishment rather than direct relation to compensation. That would be another reason for either remand or remitted or suggestion in lieu of remand or in lieu of new trial.
Can I suggest that that's sort of like a secondary, argument with respect to the amount of damages, but still going to the damages? And you calculate, for example, for the teens one back in 24 million, but there was probably more than one blank for that. That wasn't just one. And in this case, for example, you mentioned it's 42 million, but it's all not in one blank, right? 1.3 each was for each parent for the pecuniary, right? That's support the parents. That's 6 million for loss of companionship in society. And then the largest amount is the 15 million each, 10 million for past and 5 for future for each parent for the mental anguish part. So in looking at separately, right, and then seeing what evidence to support that amount, comparing apples to the other ones as well, and looking at the facts themselves, right? Because here we have someone who didn't perish immediately on at the time of the incident.
Correct.
Right? There was a time period. And to the extent that a jury can determine those particular circumstances independently that may not be echoed in other cases, right? Where a similar, even a reduced amount. So when looking at apples and apples, let's not look just at the figure, but we have to look also about the circumstance. And those are the circumstances that, again, in deference to the jury, I don't feel like we should be, well, I would have given 5 million less. I would have given 5 million more. But our judgment call is there enough there where the jury could reasonably tie that in and give value to it, even though I might have tweaked the number differently. And that's the deliberation I would have, that I need to defer to the jury. But in terms of evidence, is it fair that most of these cases are really just the testimony of witnesses and family members in most of these cases? Is that fair?
That's absolutely fair.
Okay.
Yes.
And so the weight of what a juror gives to that evidence, that's still very differential to us. So to the extent that the evidence that I give weight to, can it be fairly be determined that you look at things like age, living, the circumstances, and other significant factors? Couldn't they all weigh in to support a finding like this, where it may be another circumstance where maybe the parents weren't living together, it's a little less. But there are other circumstances too. Maybe they paid their rent, maybe they were financial, like every circumstance I think is different.
While that's true that every circumstance is different, here's precisely what the record shows in this case with regard to the 5 million of future, right? Future for the parents, 5 million for the probable future mental anguish. Miss Hatch, both the mom and the dad testified. Miss Hatch says she no longer has nightmares. She's no longer on medication for mental suffering. This is at the time of trial. She stopped going to therapy until shortly before trial, when she restarted again because of the trial and the stress of the trial is what she testified. She testified while before she would go for days without sleeping, her ability to sleep is getting better. Her father, Mr. McCowan, actually went back to college and received a degree in occupational therapy since Ms. McCowan's testing. And there was testimony from both of them. The family has begun to celebrate holidays together again. While I can't speculate on things that weren't said, I can tell the court what was. And if on this evidence and this record for the jury to say, here's the amount not connected to what the actual testimony was that came in, that's what requires reversal. I think that's what Gregory is trying to say.
Fair enough. So sticking again to the past for each parent, because on the mental anguish finding where they each got 15 million, you mentioned a little future. What was there that what could reasonably have been admitted in support of an award, whether or not it's 10 million or not, but what was the evidence in your mind. And then I'll ask you the same question for the other two lines for pecuniary and the loss of
We still
companionship.
need to cover the other damages and you've got a
We
minute
do,
left.
not good, but we're finally getting to the meat of what I wanted to get to.
Sure.
Right? So I'll, go ahead.
The testimony that came in here, the parents said they get the call, they have to rush to San Antonio, they're seeing their daughter in the hospital, and it's shocking to see her, and she's already brain dead. They transfer her to Ben Taub in Houston. She never regains consciousness. She's kind of in this same state, and then eventually they decide not to resuscitate and let her go. The testimony in I don't want to say the wrong one. I think that it's team, where the testimony is that the wife loses a husband who is exposed to steam. He is burned and an excruciatingly suffering death. And that was the 165, and the court reverses. So again, all I can offer to the court is what our precedent already says, that the similar kinds of evidence based on similar awards, the court says that's not rational basis.
Did they remand or remit?
In that one, it was remand. It was remand, I think, because there were other issues as well, I believe, with closing. Similar to Gregory, where they said, well, we would remit, but there's actually other stuff as well. And so we'll remand and actually do this over.
Is there anything tied into the any liability question where we would be required to remand? Because the award is still tied to a liability question.
If I understand your honor's question, on the negligence question, I see I'm out of time.
No, I'm going to give you a few minutes.
Okay, thank you. We've challenged the charge error. It was a basic negligence question, and how it leaves out the words like if any and fails to define proximate cause. It wasn't present for the trial. It's frustrating, right, that a basic negligence question would be in such error. We've not challenged the legal sufficiency behind the negligence finding. We have, of course, for the gross negligence, for the intoxication. Sure. But for that question, here's what I'm going to say on it, and then you can tell me if you want to hear more, or I'll come up and rebuttal. I know there's been much to do about waiver, about charge error that's waived. Here's what I want to cite the court to. Oscar Renda versus Bruce. This was May of last year, May of 2024, Texas Supreme Court. In that case, the charge failed to require a unanimous finding for punitive damages. Big deal. No objection to charge error made below. It goes up, and of course, the winning side says, oh, it's waived. The law of the case is whatever the charge says it was and didn't require unanimity. And the court said, no, unanimity is just the law. It's just the standard. I don't care if it wasn't objected to. It's reversible error. And we would argue the same should apply here.
What's the site for that case?
689 Southwest 3rd 305.
Thank you.
I have a quick question for
Yes,
you.
Your Honor.
Let's go back to Gregory just for a minute. We don't have the unsubstantiated anchoring issue in this case.
Correct.
So how does Gregory change the test that we're supposed to use? Prior to Gregory, you still have to show evidence of the nature, duration, severity, and that the amount is reasonable, right? And that all tied to the facts. And also when you're doing a sufficiency review, don't you have to rationally relate to the facts?
I think so. I think that they cite a well-known precedent that says you still have to have, this same kind of evidence of mental anguish. What's different is the rational connection language for the amount. And again, a plurality opinion does control the result in identical cases. That's 871 Southwest 2nd, 175. And so
Well, it just seems to me that in Gregory, they were telling us what not to do, right? Because they were comparing it to planes and paintings, things of that nature. We don't have that. So the rationale related to the facts, it seems when you're doing a sufficiency review, that's what you're doing, right?
Right. And in Gregory, there was no testimony, there was no evidence, there was no attorney argument in the trial court or on appeal that created the rational connection and said that amount is based on this. It was absent in the same way that it's absent here. We have similar testimony, we have numbers, we have no evidence in the record either presented during trial or from the attorney argument.
Right, I'm just seeing that the Supreme Court wanted to change the test, I don't know. What is your thoughts on that?
I think similar to Menchaca, they're trying to refine a test. They're trying to give us something that then the bar can take and say, that's right, here's the precedent. It's interesting. The appellees in their brief say, yeah, but Justice Heck is retired. Well, now so is Justice Boyd, right? So we've lost 2 and gained 2 new. And then the 3 who recused are still on the court. I don't want to repeat myself because I'm certainly out of time, but plurality results control in identical cases. And it's pretty close to identical here. And so the guidance that we have, even from those 2 sections that are the plurality, saying, here's the rational connection test, there has to be something where somebody links amount to evidence that has to be present, and it's missing here.
Yeah, and that was my question. I mean, it seems to me that it always has been rationally related to the facts, and I don't understand how it changed. But anyway.
I have
Okay.
questions for you, but I'm gonna wait until you come
Yeah.
back up and rebuttal.
I'm going to invite
Thank
you also
you.
on rebuttal to think about how Elizondo looked at Gregory and the plurality. As
Yes,
well.
ma'am.
So I'll invite that.
Yep.
Thank you.
Thank you.
May it please the court. My name is Penny Nicholson, and I'm here today representing the appellees who are Taylor McCowan's parents. As the court knows, this case arose out of a tragic accident. The defendant, Jonathan Paul Jones, killed Taylor by getting drunk, racing down the highway at a high rate of speed, and running on and colliding with her head on. Mr. Jones was unscathed pretty much by this accident, but Taylor sustained injuries that ended up killing her. But they didn't kill her immediately. She lingered for 15 days, as the court has observed.
Real
And
quick,
during
I'll
those
cut you off
15
there for a second. I know the facts. What I want to ask you about, I want to go back to Gregory. It's your position, you do not want us to apply Gregory, right?
Well, Gregory is a plurality decision, and this court has recently addressed Gregory for the first time. It's a case that I sent to the court recently. It's Elizondo versus Reyna.
Yeah, we're quite aware of that case.
Pardon?
We're aware of Elizondo. And Elizondo basically said that there was no unsubstantiated anchoring in that case. That's what they used Gregory for, correct?
Well, there was no unsubstantiated anchoring, but I don't think that's the only thing. I think that a very significant part of that case is the court wrote, as support for her assertion that Reyna did not present evidence of the amount of mental anguish damages, Elizondo primarily relies on Gregory. Then the court says, we note that Gregory is a plurality opinion and is lacking in precedential value.
No, I understand. I just want to know, my question is how does Gregory apply? If we do not apply Gregory, does it change anything as far as our review? That's what I'm trying to get at, because I know Gregory stands for you can't have unsubstantiated anchoring. And then it says you have to have the facts rationally related to the amounts, correct? Was that not the case before? Did it not have to be related to the facts?
Well, I
Could you just say anything.
Well, I think the thing that's a little bit different, and it kind of is reflected in this part of Elizondo that I was quoting, is that when the rational connection part in the concurring opinion from Justice Devine, he said, look, the problem with the rational connection test, which is only supported by the plurality, is that when you're talking about damages like mental anguish damages, you're not going to have rational connection in the sense of like you would in a lost profits case, or a medical damages case. And so it's the rational connection is just proposing a test that in mental anguish damages, and that sort of damages, loss of companionship in society, it can't be applied in just like, okay, we're looking at this one thing and this one thing, and it all adds up like a lost profits case. So I think that's what the.
Can we go directly there? Looking at the record, could you point to the court specifically? And I'd like to start with the 15 million award to each parent under the mental anguish charge. Can you share with me what evidence supports the 10 million for the past and 5 for the future for each parent?
Well, I think the evidence in the record is really pretty abundant.
So let's
Yeah, no, I will. I mean, and I think it's significant that that was the highest damage that the jury awarded, because they found out about the accident when the mother got a call from about telling her that her daughter had been in this wreck. She immediately called Taylor's father, and they raced down to San Antonio. They lived in Houston. They made a trip that normally would be over 3 hours in just 2 hours. When they saw their daughter in the bed, they just said it was their worst nightmare.
Would it be fair to say then that the evidence is predominantly from the testimony offered by each parent?
Yes.
Is there any other evidence tied to this award, in your opinion, in the record, aside from those two pieces, those two testimonial evidence? Any other evidence?
Well, there was testimony from the paramedic, and there was testimony from the officer. And while that didn't go directly to the mental anguish, it provided evidence of what happened in the circumstances and gives some context to it.
Specifically to the past, would that be the testimony limited to the events between the incident itself and the time of her death, which was several days later?
No, I don't think so.
Okay, elaborate, please.
Well, I think there was a substantial evidence about the mental anguish that they had in the past, in the sense of prior to the trial. Both of the parents testified about her father testified about how much he missed her, and how he specifically missed, they used to talk on the phone every Sunday, and have these very deep and meaningful conversations. And of course, when she died, he no longer had that. And he testified that he would visit her grave, I think on at least a weekly basis. And he would take sunflowers, which were her favorite flower, and he would take his little lawn chair and sit, and he would talk to her, and he would cry. He said he still cries every time. I think that is powerful evidence of continuing mental anguish.
Very good. Anything else on?
Well, and the mother testified about how and you're asking about.
Well, I don't mean to ask you to parlay all of the evidence, just I'm trying to see what evidence was presented. It was the testimony through the mom, and her father, her mother, and And just want to be clarified if there was anywhere else, any other evidence to support that award.
Well, the direct evidence came from the parents.
Right.
And I think each of the parents testified about the anguish that they observed the other one experiencing.
Very good.
So testified about their own mental anguish and then the
So
other
to,
parent.
and so if I could move forward then to the loss of companionship side, would that be similarly limited to the testimonial evidence of both parents?
Yes.
Any other witnesses?
No.
Okay, and then the same for the pecuniary loss.
Yes, it would be the same. It would be the testimony that came from the parents.
Then I'll invite you to respond specifically to what you heard appellant's counsel share about, I guess, the lack of evidence that would support the amount that was actually awarded, that it seemed not related to any, or at least that it was excessive. What would be your, your content in terms of what evidence she appears to be disregarding?
Well, I think the evidence from the parents was extremely powerful. It completely has devastated them. It's changed their lives. And
So how does that compare then? Because I did ask you to refer to other cases where similar evidence, again, is limited to the testimony of family about this type of award, right? The mental anguish award. And she pointed to other cases where the award was less and still deemed excessive. Can you point to other cases where you would submit to the court that is more in line with what the jury awarded in this case and should not be deemed excessive? Can you point to any other cases?
well, you're talking about comparable damages type situations.
Yes, with comparable evidence.
I'll look at that after the argument and send you in any cases we found, but we think the damages are, tied to the specific case and the findings that the jury made in that case, in this case. And each person's their experiences with the mental anguish and the loss of companionship in society are unique. And we feel like they're fully supported in this case.
Very good. Please proceed.
The other thing that's we think different about this case is that throughout the case, starting in voir dire and then even into the closing argument, the defense counsel told the jury that it should decide the damages, award the damages based on the value of Taylor's life. And we think that that is something that distinguishes this case from the other cases. It started out during voir dire saying a juror got excused, I think excused, but at least questioned based on, she said, I couldn't be on this jury because I can't award damages based on the value of a person's life. I couldn't do that. And then in closing arguments, the defense counsel repeatedly said, your job here is to put a price on Taylor's life. And he even said, that's your job. I'm not going to tell you how to do it. It's your job to put a price on Taylor's life. It's your job to find the value of Taylor's life. And, I think that changes, it makes it different from the other cases that are decided. I don't think you can come in and have defense counsel come in and say, award damages based on the value of this person's life and then just ignore that. I think it changes things. It's not like this is a lost profits case where there are very specific instructions. You know, and I think the damages are especially sustainable in light of the statements that by defense counsel that they should be putting a price on Taylor's life and determining the value of Taylor's life. Let's see here. And another thing is that in opposing counsel's argument, she talked about how there was kind of an overemphasis on the facts, but I think the facts are important here. And the grief that the parents have suffered, the mental anguish, the loss of companionship in society, those things are critical. So I don't think that they should be disregarded or ignored. Also, some states have caps on damages, and Texas does not. Texas has a history of having great deference to and putting a lot of value on the findings that the juries make, the damages that the juries award. And I think that's significant too. Then there's also, with respect to the turning for a few minutes to the jury charge complaints, these jury charge complaints are waived. The case that I haven't looked at the case that was cited during the oral argument, but it sounds like that was related to a substantive kind of matter, like in order we have to have unanimity. And these jury charge complaints are completely different from that. These are more garden variety type objections. There's the failure to put in the if any after the word negligence. That's that's just a standard objection. If they had brought that objection to the attention of the judge, in all probability, the judge would have added it in. The plaintiffs wouldn't have opposed it. And that's another reason why, you shouldn't be just allowed to skate on that. And also, it probably would not have made any difference in the outcome of the case and the verdict, whether there was an if any in there or not. And the other objections that they talk about are similar. There are things that there was one, for example, there's a standard instruction that's often given about the relationship between the parties being considered in the award of damages. There was no objection to that. There was no request for that. I mean, the rules concerning preservation are important. And you shouldn't be able to come in after the fact and say this instruction wasn't given when it wasn't even requested. And once again, since it was a standard PJC type thing, it probably would have been given and the plaintiffs wouldn't have opposed it. So it shouldn't be allowed to it's like an ambush kind of thing. And in addition, once again, it seems unlikely that it would have changed the outcome in the case anyway. Let's see. There was another one of the instructions that was they listed in their jury charge complaints. There was a statement in the charge that up at the beginning in the preliminary instructions that said, pursuant to Texas Penal Code 8.04, voluntary intoxication does not constitute a defense to the commission of a crime. There was no objection to that. Once again, they say it's a comment on the weight of the evidence. It doesn't seem to be a comment on the weight of the evidence. It's just a standard instruction. So and this is summing up because my time's just about out. I think this was a horrific case with horrific damages, and I think the evidence fully supports what the jury did. And I think it should be affirmed. If the court has any questions, I'd be happy to answer them.
No, thank you. I was going to give you some more time if you needed it.
Well, let me take a look then, because I had,
Let me give you a couple minutes if I may, but I'd like to invite you to address the complaints regarding the punitive damages, please.
Well, the complaints regarding the punitive damages, the whole purpose of punitive damages is to punish and to send a message. I mean, while if the day that Taylor had died had been used as the basis for some of the other damages that were asked about, that would present a wholly different question. But when it's punitive damages, that's the whole point of punitive damages, is to send a message. And maybe what the jury wanted was for the defendant to remember that through these punitive damages, that he killed Taylor on this day. And she died on this day because of his getting drunk and causing the wreck. The punitive damages were actually much smaller than the plaintiffs had asked for during closing arguments. The $100 million that was requested was actually something that was suggested just for the punitive damages. And the jury cut that way back and chose an amount that would send a message. And in terms of, the statement that the damages were just pulled out of the air, I think that's not true. I think there is a very rational, the way the jury awarded the damages was very rational. The highest amount of damages were for mental anguish. And I think that based on the testimony in the case, that was where the bulk of the damages were. The parents were completely agonized by the death of their daughter. The jury awarded substantially more exemplary damages in the past than in the future, because as horrific as this was, and as much as it's going to affect them the rest of their lives, the trauma from the mental anguish was reduced in the future. Now, with the loss of society damages, it was the flip, but it also shows reasoning on the part of the jury. The past damages were significantly smaller than the future damages because there are many more years that the parents are going to miss their daughter in the future than there was in the past. Similarly, with respect to the pecuniary loss damages, those were lower in the past than they were in the future, based on all the evidence of what kind of person Taylor was. It's pretty much undisputed that she would have continued to care for her parents through the rest of their lives. She already did that. She made sure that her mom took care of her health issues. She drove her to doctor's appointments, and she would have continued to do that for the rest of her life. She also provided advice and counsel to her father, got him to get his college degree. So that kind of is a pattern I see in the damages that were awarded. Do you have any?
Very good. I don't think we have any other questions. If you want to sum up,
Okay, well, let me just take a wonderful.
rest and close or whatever it's
Mm.
called. Yeah, close.
Okay,
Thanks,
thank you.
trial, rest, close.
Thank you.
Thank you, counsel.
May it please the court, I want to start with Elizondo because the court asked me to address that case. And we've got an August 2025 opinion that needs to be talked about. We mentioned it a little bit before in the National Guard argument. Here's what I think, at least what I pulled out of Elizondo, what I highlighted when I was going through it. We have an auto accident, we have injuries, we have something that requires, this life altering, takes him out of the National Guard that he loves. 6,000 for past mental anguish, 12,000 for future is our universe with regard to mental anguish. And the first citation to Gregory, and I think you mentioned this, Justice Spears, is about unsubstantiated anchoring. And that's when they're talking about, well, it's a plurality. But then this court at the end of the opinion actually does articulate the no rational connection test, right? And citing to Gregory. But looking at that record, what happened was Reina's counsel had actually suggested this kind of per diem argument. And the court says, he suggested that as compensation for mental anguish, the jury should award him $25 a day, approximately 1 hour of his National Guard duty. And much of the testimony from Reina was tied to the loss of his military service. So the court said we can't say that means there was no rational connection to the facts of the case and the amount awarded to the 6,000 and the 12,000 in the future. And then the court actually does the math and kind of shows us exactly what the per diem would have been, and concludes that those amounts are both reasonable and rationally connected to the evidence. To your point, Justice Spears, is that a new standard or has that always been the standard, right? The court doesn't seem to question. You always have to have evidence to support an award in a jury verdict. You have to have evidence that says that supports this. I want to cite the court as well because you asked about, are there any, post-Gregory cases, Chief Justice Martinez and Ariano versus Villegas, which is January of this year out of Austin. You've got, you have an auto accident with someone who was intoxicated. You have a head-on collision. You have serious injuries. 15,000 in past mental anguish was the award there. And the court is citing to Gregory and says, not only must there be evidence of the existence of compensable mental anguish, but there must also be some evidence to justify the amount awarded. Cite Gregory versus Chohan, citing Signs versus Fidelity, right? Relying on this standard. And then in that case, talking about the evidence that was actually offered, which was admittedly less than here, where it was still the testimony of the person who was hurt, but kind of less extensive than the record we have here. And the court sustains the challenge to the legal sufficiency and says it's not enough. So there's one more kind of case. Yes.
So let me ask you, I'm struggling with, I understand that as a reviewing court, we have a duty to ensure that non-economic damages are a result of rational effort grounded in the evidence to reasonably compensate the plaintiff for the injury, correct?
Correct.
Now, we also, as a reviewing court, for example, in credibility determinations, we defer to the fact finder. Now, when we review the record up here, we weren't there to see Ms. Hatch or Mr. McCowan testify. We don't know what emotion, how broken, or we don't have the benefit of having been in the trial court. We only have what's written. And what I'm struggling with is that now we're looking, so Gregory tells us that we should not allow unsubstantiated anchoring, but yet we're asked to look at other courts and other reversals or decisions. To me, that's anchoring the value of these plaintiffs to some other cases that are unrelated, not connected. So can you sort of I guess, address that for me.
In Gregory, I think it's where the footnote appears where the court talks about kind of verdict comparisons. And Gregory was talked about in the appellate CLE in Austin recently. And it was like, okay, is verdict comparison legitimate? Are they endorsing it? And they seem to not shy away from it. They seem to say this can be something we look at, while acknowledging what Your Honor just acknowledged, which is every case is on its record, right? It has to be. And so if they're not going to give us a mathematical formula, then what we have is precedent from other cases saying, yeah, there was evidence of death, of tragedy, of sadness. Was there evidence where somebody, the advocate or the witness, attempted to tie an amount to such evidence? If yes, we uphold. If no, we reverse. And that is the consistency that we see in the precedent in Gregory itself and post-Gregory.
So let's talk about question 4, which is pain and mental anguish for Taylor McCowan. And the jury awarded $24 million. And that is for her conscious physical pain and emotional pain and torment and suffering. And we know that she was in the car for 40 minutes while they tried to extricate her. They cut off the roof of her car. Then paramedics finally took her out. And I think it was about a 10-minute ride to the hospital. And we had paramedic Jennings testify that she was responding to pain. The exhibits that were introduced and the evidence that the jury heard is that she had a fractured skull, a broken nose, fractured ribs, lacerations to her liver, her spleen, her kidney. She had a bone sticking out of her ankle. She had lacerations to both legs. And she was hemorrhaging. They had to give her blood transfusions on the way to the hospital and use an ambu bag because her oxygen levels were declining. So tell me how 24 million for 50 minutes. And I understand you can break it down by the minute, but so tell me why you think that's excessive.
She was unconscious. Even the paramedic
But the paramedic gave her a 6. He said he would have given her a 5. He clearly stated in his record, in the exhibits, multiple times that she was responsive to pain.
Here's what she was responsive to. The knuckle, right? The fist, the sternum rub. He says she's not responding in any other way. This is for reporter's record at 65. When he talks about this sternum rub, which is the only reaction they were able to get from her, they come up on the scene, right? They've got to use the jaws of life to take the roof off. They're pounding on the window. Miss, excuse me, miss. They're yelling at her. No response. She's not moving. She's not flinching. She's not, you mentioned the bone in her leg. She's not writhing. She's not moaning. They have to physically open her eyes, right? She's not responding. Once he gets to her, he calls it not gentle. I don't know if you've seen a video of this, but it's not gentle, right? We see substantial bruising and breaking of rib cages and whatever. They take a fist, right? To try and see, is there any responsiveness? What he describes as a wince, and he says in the same breath, he says it twice, she was not responding in any other way. So other than when he intentionally hurt her, right? Which is what you're trying to do. Did he say there was a wince, not an opening of the eyes, not a struggling, right? A reflexive wince. And he calls it a wince again. And on that same page, he said, she would wince, but we got no other response out of her. And so to say, well, she was clearly suffering from all of these injuries and writhing in pain for the 40 minutes. I don't think there's any evidence of that in the record. The paramedic himself says, this is the only reaction I got out of her in all, both the police officers and the paramedics trying to get her to respond, and there's no response. So when, again, we have to look to our precedent, right? You can't just say, well, Melanie doesn't think 24 million is not right. I mean, that's not the standard. And so what do we look at? We've cited in our brief, Cresthaven, 16 days of what we know was conscious pain and suffering. Jury awards 4.5 million in survival damages. Court of Appeals reverses. And actually, in that case, they did go ahead and submit the remitter of 3.5 million. And so to say there's no, there, I would disagree that the record shows she was conscious for 40 minutes. I think the paramedic's testimony makes clear that she wasn't. And I actually think the fact that the only pain response they got out of her was this wince actually proves she was not feeling pain in the other ways. But I think, you know, my light is going off if I can finish the thought. If there's not sufficient evidence of consciousness at all, but even if she were conscious for 40 minutes, which includes the ride to the hospital, all of it, right? Moment of accident to showing up at the hospital, anesthetized, coma, scale 3 on the Glasgow. Even that compared to our precedent, 24 million, not connected
But
to
it's
the
not
actual suffering.
24 million, is it?
I'm sorry?
Because you're still adding all of the lines together. Which line is it?
It was 24 million on that line for survivorship. Survivorship. It was a straight 24 million.
Got it. Wrong line I was looking at.
Word to her directly.
Yes, that's the pain and mental anguish, right? And that's to Taylor.
That's for conscious pain and suffering. And as we've cited in our brief, cannot be for unconscious. Can't be.
I'm just gonna ask you one question. You can agree or disagree with it.
Okay.
Because I'm reading Elizondo. My esteemed colleagues on that panel wrote, and agree with this here, but to the extent that the panel of this court has already said that the Gregory does not provide precedential value because of its plurality. It also notes specifically, and here it is, that the majority of the court actually rejected what the plurality and Justice Devine's concurrent opinion referred to as, quote, unsubstantiated inquiry, which again is tying the amount of mental damages to actually, to evidence, to other objects or values. I think their concern, would there not be, was that we weren't tying it to some sort of passion or punitive, like we're just, and note specifically the argument that was made at closing that was not made here, right? About, we're spending too much on military aircraft, kind
Right.
of like stuff. That obviously, which is not present here, right? But the point being is that there was not really the majority of the court, which is why there was plurality. There was no majority that actually agreed on pretty much anything with respect to mental anguishes and mental anguish damages. And at least that was the perspective from that panel of judges who reviewed it. So to the extent that it is relevant in this case, that will remain to be determined. But what would you say to that position taken by the panel of our court?
I would disagree that the rules set out regarding non-economic damages were only within the plurality opinion of Gregory. It's one of those fun opinions where you go through and you say, okay, well, that was 4 justices, then you flip over and you say, well, that was 3, we have to map it out. But importantly, the 4 justices, the majority, right? 4 of 6. The age-old, right, precepts we have about non-economics are cited there. The rational connection all throughout the majority, right? So to guard against arbitrary outcomes and to ensure that damages awards are genuinely compensatory, the plaintiff in a wrongful death case should be required to demonstrate a rational connection grounded in evidence between the injuries suffered and dollar amount awarded. That's not the plurality. And I think that's what allows the panel in Elizondo to, at the back of the opinion, quote to that standard, cite to Gregory, not talking about majority plurality, saying it's always been the case that we need evidence to be tied to amount. And in that case, they were able to say, here's where that happened. Here's counsel's statements doing that. And in this case, nowhere in the record has that happened.
Very good. Thank you very much.
Thank you.
Your case has been submitted and opinion forthcoming.
All right.
Court adjourned.
Thank you so much.